Greetings, everyone. In this video, we want to look into this question which are getting these days. A number of parents or single parents are coming to us to say they have children born in South Africa. Either the mother or the father is South African, but they are no longer together. Can they then apply under their children to remain in South Africa? I am Ngabuto Nicholas Mapena. Please like the video, subscribe, circulate, and we hope our lawyers who always follow this channel will also give their legal understanding to this question. Right, currently, as it stands, if one of the parents is a migrant, has a child in South Africa, a child registered under them, the two parents, or under the South African parent, the child is South African by birth. But currently, a migrant parent cannot then claim or apply for a permit or visa to remain in South Africa on the basis that the child was born in South Africa, particularly if the child is below 18. Because when you apply for a relative visa, the requirement is that the relative that you apply under must demonstrate that they will take care of you financially. Because you're coming into the country, you are coming on the basis that your relative, your close relative, is in South Africa, and they want you for a period of time to be in South Africa, and that they will be taking care of you financially. So a 12-year-old or a 15-year-old who is school going is considered a minor and they cannot take care of you financially. That means such a parent cannot apply for a visa or for a permit on the basis that the child is born in South Africa. What normally happens, which is the current situation as we understand, I've been talking to some people at the Department of Home Affairs head office to try and understand how they deal with this question. And one of the officials said to me that if the custody of the child or if the migrant parent has the custody of the child and they are now separated with the partner, whether it's the mother or the father of the child, but the migrant parent has the custody of the child, the migrant parent will have to take the child to their country of origin. In this case, as we're talking mainly about Zimbabweans, is that if we are a Zimbabwean parent, we have a child with a South African partner, and you are now divorced on separation, and you return the custody of the child, it means you have to take your child back to Zimbabwe. The child is born in South Africa. Assuming the child then turns 18, 17 or 18 while in Zimbabwe, the child becomes a Zimbabwean through descent. Because the child is not born in Zimbabwe, but the parent or one of the parents is Zimbabwean, and the child is resident in Zimbabwe, the child can apply for a Zimbabwean citizenship through descent. But because now the Zimbabwean constitution does allow for dual citizenship, so the child can apply for a South African citizenship when they are above 17 or 18, to say they are South African by birth and they are Zimbabwean by descent. So a child can hold two citizenship as the Zimbabwean constitution now allows dual citizenship. But this does not mean that a Zimbabwean parent can apply for a permit to remain in South Africa on the basis that the child is born in South Africa. Unless, of course, there are certain circumstances, special circumstances, that will make it difficult for the child to leave South Africa if the migrant parent, or in this case, the Zimbabwean parent, has custody of the child. Assuming the child is receiving medication, is having a medical problem, to an extent that if they were to leave the Republic of South Africa, it will threaten their own life. Such an application can be submitted to the Department of Home Affairs, who will have to evaluate and see whether, based on the medical reports of the child, it is necessary for the child to remain in South Africa. But the child is under the custody of a migrant parent. It is under such circumstances that we think the Department of Home Affairs may then grant a permit or a visa for a parent who has the custody of the child, who happens to be Zimbabwean or a migrant, to remain working in the Republic of South Africa to take care of the child. So it is under those special circumstances. But ordinarily, it is not possible under the current Immigration Act that one can apply to remain in the Republic on the basis that they have a child with a South African partner whom they are now on separation or whom they have divorced. Just like a Zimbabwean adult, I've seen this case, it has happened. I've seen other adults, Zimbabweans, who are over 18, who have gone to the South African embassy in Harare to apply for South African citizenship on the basis that one of their parents is born in South Africa. You remember our fathers came to South Africa in the 70s to work in the mines, known as Wenela. If then they had they married a South African lady, or a South African, your mother is South African, or your father is South African for that matter. You were born in Zimbabwe, you grew up in Zimbabwe, even if you are 30 years old, which I have seen happening, you can then apply for a South African citizenship through descent on the basis that one of your parents is a South African. So you can actually qualify you do qualify for a South African citizenship. So in this case, if the child is born in South Africa to a migrant parent, and one of the parents decides to relocate, in this case, because there is no any other available visa or permit that the migrant parent can move to, it means you have to take back your child to Zimbabwe. When the child has completed schooling in Zimbabwe, is an adult, and they wish to come back to South Africa, they can then claim citizenship on the basis that one of their parents is South African. So we thought we needed to clarify this because we have been receiving many calls, many inquiries, people saying, I've got an 8-year-old child whose mother or father is South African, but I'm the one responsible for them. Should I qualify to apply for a visa so that I continue to support the family? We are told by some officials that at this stage it is not possible. We are not sure though whether in 2022 the South African Department of Home Affairs will look into this issue again and probably provide a waiver for such. But as it stands, you cannot apply for any visa or permit on the basis that your child was born in South Africa. If you retain custody of the child, you have to take your child to Zimbabwe. Thank you. I think this clears these questions that people have been asking. Thank you so much. Please like the video, circulate, subscribe, and write your comments. We want also to hear from legal experts who are following this YouTube channel on what they think is their understanding of the Immigration Act. Bye-bye.